Yeah, just know, like, you're gonna have to forgive some things. You'll see, like, some, like, maybe tape on the walls and, like, music that's gonna, the score is not done, things that'll, like, tweak and change. But by and large, it's the movie you'll see. But please go see it again August 9th because it'll be even better. And we're nervous for you to see it today, but also just so excited because I feel like I can trust that you guys know that it's not totally done, but you'll still really love it, and we hope you do.
Hi friends, it's Katie from Without a Crystal Ball. Welcome back to my channel. Blake Lively has been called a liar in federal court, someone that is lying and hiding behind these laws, trying to get trouble and punitive damages by denying a business the right to redress and bring their complaints and grievances to a court of law, which is actually a protected right under the US Constitution. According to Baldoni, Friedman, and the group, they have a First Amendment right. There's a doctrine that's been used in court that is a precedent that states that as long as you don't bring a frivolous lawsuit and as long as your lawsuit is being done with the intentions to seek damages against the person or the company that you're bringing them from, even if it harms them, they can't be penalized. You can only be penalized in the event that it's deemed frivolous. And in this case, they say you can't decide the merits of the facts of this case on a motion to dismiss, which is supposed to be about determining whether or not the complaint falls in the law. Blake Lively's contract was also brought up and how she breached her contract. They had so much to say in this motion to dismiss. And as always, I'm not here to tell you as a lawyer, because I'm not a lawyer, whether or not these arguments are solid or awesome or whatever. But I will say they're using the Noor-Pennington doctrine. And this is an established law that 100% says it precludes the imposition of liability for the exercise of rights protected by the petition clause of the First Amendment. The First Amendment protects the right to petition the government for a redress of grievances. The Constitution safeguards the American right to ask the government to take action, such as bringing legal claims. In a federal court, federal law and civil rules of procedure are above and before anything at a state level. And if there is something that's in the state and the federal, like the Constitution or a law, that will take precedent. And they're saying federal law is above this California law. And I think they're making a really good point. And it's a really good, solid legal argument. But outside of that, I want to just hone in on something because one of the details that she's trying to say is that they can't do this because she has a right to bring forward these claims, right? She has a right to speak out against harassment. It's protected. She's trying to use litigation privilege. And they're actually arguing that she made defamatory statements herself. They are not the defamatory statements that she would like to claim. Like she was saying that they were barred by the statute of limitations, if you remember that. Trying to say that, when she brought forward her allegations to Wayfarer back in May of 23, that the statute of limitations was up. They're saying, no. We're not talking about that. We're talking about when you went to the New York Times. We're talking about during the period of promotion. We're talking about this very narrow window when you and your husband and your PR people started blabbering all over the place about us being sexual predators. So it says, Lively implausibly argues that the defamation claims arrived from the 17-point list presented to Wayfarer in or around November 23rd. That is wrong. Although certain of the Wayfarer party's claims implicate the 17-point list and Lively's conduct during production, The defamation claims arise from statements made between July 2024 and December 2024. So that's the window they are talking about for defamation. Now, where they go with malice is amazing. This is literally the part of this entire actual response to Miss Lively, and it kind of ultimately dismantles the claims that she's trying to hide behind 47.1, which is a protection that she would get for bringing forth claims of sexual harassment under California law. They state that in order to get this specific protection, they have to make them without malice and with a reasonable basis in facts. And that's why they say Lively's arguments all fall flat. Lively fabricated her allegations of sexual harassment either wholesale or by exaggerating benign and not harassing interactions in a concerted, malicious effort to seize control of the film and later to restore her reputation after a well-publicized series of marketing missteps that sullied her reputation. And a lot of the arguments that I have been making and speculations I was believing as far as what they were saying in their motions are exactly what they argue here. Remember how I said that she was using the harassment to gain creative control? They literally spell it out. As a part of subsequent negotiations, Lively was granted an executive producer credit, a ceremonial title often given to talent of Lively's stature. However, Wayfarer and Sony refused to agree to give Lively a true producer credit because such a title would not accurately reflect the role she was asked to play. Wayfarer did not request or require that Lively contribute to the film in any capacity beyond her role as actor and executive producer. Although at the beginning of production it appeared they would have a positive collaborative partnership, she had other intentions. And they also note, and they're referencing that Forbes interview where she says that she does the rug pull. They quote her of saying in 2022 that Lively admitted, although not to Wayfarer or Sony, that she needs to have authorship in order to feel fulfilled, which producers and directors often perceive as a rug pull because they hired her to be an actress. And they say that's exactly what Lively did to them. In fact, they say Lively's pattern of domineering interference caused unending interruptions to the production process, leading to entirely unnecessary stress, chaos, and delays. To drive home their point that Lively only brought up these alleged sexual harassment claims in order to get more control, this is what they said. They said that when the strike ended, out of nowhere, they blindsided them with this agreement, 17 points of non-negotiable conditions. And they drafted it for the apparent purpose of insinuating or outright claiming that Baldoni, Heath, and others had engaged in sexually inappropriate conduct during filming. But nothing could have been further from the truth. Wayfarer and Sony attempted to revise the document to make it factually accurate, and her counsel responded that the list was not open for negotiation. They were forced to sign the document as is, despite the falsity of its insinuations, or else they would lose millions of dollars, cost hundreds of people their jobs after they had been out of work for months, and destroy their relationship with Sony. Notwithstanding the insinuations, the demands themselves were agreeable because they were already in place. But regardless, she used this to extort the Wayfarer parties into giving her editing rights, allowing her to create her own cut of the film, removing Baldoni from all marketing and promotional materials, sponsoring Lively for a PGA mark, which Wayfarer parties characterized as extortion in real time. Remember that letter that Mr. Heath sent to Wayfarer basically saying that without going into the details, we're being extorted by Blake and she's holding these threats over our heads. That's what that, and I was saying, see, this is why they're saying it's extortion. So Blake arguing that they only bought this extortion claim up now it proves they're just doing this in retaliation. They're saying, no, We said this in real time, and excluding Baldoni from the premiere among other ruthless demands. And she said, to the extent that Wayfair assented to these demands, they did so staring down the barrel of a gun. In the FAC, the parties dismantle point by point the insinuations in the 17-point list, as outlined in the pleading over a collective of 391 pages, including Exhibit A, lively fabricated, materially mischaracterized, or grossly exaggerated all of the allegations she made in her CRD complaint and federal lawsuit. They are saying she's a liar. She's a liar. And interestingly, I'll just say this. Often, when you're doing a motion to dismiss, your lawyers will have you do a declaration. And it's much like what we saw with Jed Wallace, where he stated, Lively's accusing me of these things. And under oath and the penalty of perjury, Jed Wallace stated he did not do what anyone was accusing him of doing. If Jed Wallace is lying in that declaration and they can prove he's lying, he can be sanctioned. On the flip side, when Ryan Reynolds and Miss Lively did their motion dismisses, there were no declarations from any of them under oath, under the penalty of perjury, sticking to the claims that they were making and denying. That to me says so much. I have done motions to dismiss, and every single time I have had to file a declaration under the penalty of perjury. If you're innocent, generally that's what you do. So here's what they say she lied about. Lively falsely claimed there was no intimacy coordinator when Lively was aware that one was engaged 6 weeks before filming began, even though she refused to meet with her in pre-production, forcing Baldoni to personally relay the coordinator's suggestions about mechanics of a scene. She falsely claimed that certain Wayfair parties insisted on being around her when she was undressed or breastfeeding, when in fact, Lively openly breastfed on set and no one ever entered her guarded trailer without advance permission. So she had a security guard outside of her trailer at all times. The FAC includes a text message from Lively to Baldoni inviting her to her trailer while pumping breast milk. And that was after the events that she claims where she had been sexually harassed. She falsely claimed that she was forced to be nearly naked during the filming of a birthing scene, when in fact she was wearing black briefs, a hospital gown, and a pregnancy suit, and only her legs showed. Lively falsely claimed that Wayfair hired a random friend of Baldoni's to play a gynecologist, when in fact the actor is a Shakespearean-trained professional with an MFA in acting from UCLA. Lively falsely claimed that she was shown porn by Jamie Heath when, in fact, in relation to the filming of a birthing scene, Lively was shown a single non-pornographic clip from the video of Heath's own son's home birth. Lively falsely claimed that Baldoni harassed her during the filming of a purportedly soundless slow dancing scene, an allegation definitively disproven by raw footage with sound that Lively apparently did not realize existed. Lively falsely claimed that Baldoni fat shamed her, when in fact he privately inquired with her personal trainer about her weight to prepare for a lifting scene due to his long history of back problems. Lively also falsely claimed that there was no such scene, but the relevant portion of the script is excerpted in the first amended complaint. Lively falsely claimed that Baldoni admitted to committing sexual assault when in fact he disclosed that he had been the victim of sexual assault. So these claims that, he's a predator because he crossed boundaries, and that car ride where she said it made him reevaluate, he's denying that. And they say those are just a few examples, and they don't even come close to capturing the full scope of her lies. They said, in the strongest possible terms, the accusations made by Lively concerning sexual harassment and retaliation are false, and she knew they were always false. Lively acted, they believe, in malice and made her accusations without a reasonable basis in fact. And they say this is not a decision for a motion to dismiss. This is actually a fact that has to be determined in court. And I believe they're correct on that. They also argue that the 47.1 would not apply to Sloan's or Reynolds on Lively's behalf because they're third-party communications and they don't have protections for them. So they're calling her out for the lying to try to prove malice, right? And they're saying she willingly knew this. And they're also bringing up things that I brought up last week, where the fact that she didn't have these claims investigated by proper authorities. So they mentioned point blank in this complaint, in this response, that she filed her CRD, but she never intended for CRD, the Civil Rights Department, to actually investigate it. And then instead, she sat on it after she went public. And she sat there for like, I don't know, a couple weeks before she ever filed a lawsuit, which she has technically up to a year. But most often, when someone gets a right to sue, they file the same day, the lawsuit. But in their case, they're saying she never filed it. She never asked for an investigation. In fact, she waived the investigation. She never reported it to HR. She never took the steps to actually have these claims investigated to be verified that they were truthfully sexual harassment. And so their arguments are to prove malice, factors such as failure to investigate, her anger and hostility, and reliance on unreliable or biased sources create the inference that Lively had serious doubts regarding the truth of her statements. Because again, if you believed what you said was true, and if you believe this, you would allow CRD to investigate. You would allow the EEOC to investigate. You would make a formal complaint to HR because then the investigations could be done. It says malice will be inferred if the defendant fabricates her story. It is the product of her imagination or is based wholly on an unverified information. They say Lively's motive for making the statements and whether she did so to harm the Wayfarer parties are also relevant. As to the allegations of sexual harassment, she clearly knew they were false at the time. She made them because she was describing her own purported experiences. As outlined above and exhaustively detailed in the FAC, she was not sexually harassed on the set, and she was grossly mischaracterized or outright lied, fabricated the events in question, even in sworn legal documents. Lively and her co-conspirators engaged in a coordinated campaign to exaggerate benign interactions in service of a false narrative that she had been sexually harassed. They did so to instill terror in the Wayfarer parties and leverage it to accumulate power. They're saying the whole premise of these allegations was so that she could take control of the film. And if you know anything about Hollywood, don't be disillusioned. People use extortion like this all the time. Women and men will extort other people on the premise of filing false allegations for whatever in order to get what they want. So this idea that, Me Too is dead because of Blake Lively, no. There are some people that get harassed and have been victimized on sets. There are also other people that weaponize these same claims to get what they want. And they're saying, Wayfarers, that she's of the party that used them to get power. And she did, because ultimately it was the document that she signed, made them sign, that gave her editing control. It gave her an opportunity to extort them and threaten them to get a cut with Sony, to threaten not to be a part of the promotions. And I am so glad they brought this up because I pulled this letter that Jamie wrote about the extortion back in June as proof that this was not a new claim against them, against Blake. Like they just made this up. Because again, on page 23, they say the FAC alleges that Lively obtained first a producer credit and then a coveted PGA mark by threatening and coercing the Wayfarer parties into granting her the credit and writing a letter of support for that mark, an act that Jamie expressly recognized even at the time as extortion. These allegations alone are sufficient to defeat her motion to dismiss claim for civil extortion. So they're saying that she extorted them to get that PGA credit, which is what so many of you guys have been saying in the comments. Like, yes, she did. She got something. She got the PGA credit. That's what they're saying too. So at the very end of that same argument, they say she further claims that she cannot have engaged in extortion because she did not obtain anything of value from them by means of threats. They say, as set forth above, that is untrue. She threatened her way into the valuable producer credit and PGA mark. But even were that not the case, it prescribes extortion, notwithstanding that the defendant ultimately obtained no money or property by means of this threat. Here, they have alleged facts sufficient to state a claim for civil extortion based on at least the demand that Reynolds and Lively, that if they didn't issue a self-destructive statement taking blame for Lively's press wars, or else the gloves would come off and they would attack Wayfarer in the press. The FAC alleges that Lively demanded consideration, and if they didn't do it, they would threaten and destroy their business. I don't know what's going to happen with the extortion claim. I have no idea, but they have really solid arguments here. And when it comes to the contract violations and the issues of the claim for breach of contract or breach of implied covenant of good faith and fair dealing, she argued that they failed to state a claim of this for failure to identify a specific contractual provision that was frustrated. Much like how Ryan Reynolds said, well, you didn't identify exactly what it was that I did or what I said. She played the same exact card. They also said that she even argues with a straight face that she did not fail to cooperate with the parties. However, the Wayfarer's parties can and will amend to add additional specifics if needed. So here they offer how she actually violated. Lively's contract requires that her right to consult and approve on certain aspects of the film's production and marketing be exercised in a reasonable manner and not so to frustrate what Wayfarer's full and timely development, production, and or exploitation of the film, and or to force Wayfarer to bear any additional costs with respect to such consultation or approval rights. The contract further specifies that Lively would not have the right to terminate her performance under the contract except in extremely narrow and inapplicable circumstances. Yet, as alleged in the FAC, she threatened over and over to terminate her performance of both acting and promotional services. She would not do any act that would interfere with the complete enjoyment of the rights and privileges granted to Wayfarer. Lively's claims that she did not frustrate any specific contractual provisions is frivolous. So she had a contract that basically stated that she could give her input on the production and the marketing, but she could not use that in an unreasonable manner. So she couldn't delay the movie, she couldn't increase the costs, and she could not get in the way of Wayfarer releasing the film or marketing the film. She was only allowed to quit under very specific reasons, and they say she did not meet that. And even though she didn't meet that, she continued to threaten to quit over and over and over. And she promised not to interfere. She agreed not to do anything that would stop them from fully using the rights they had paid for, like her acting, likeness, or promotion. And that meant she couldn't do things to sabotage the film's release, marketing, or the financial success. Ultimately, they're saying that she abused her approval rights and to delay or obstruct the movie. She threatened multiple times to quit, and her behavior interfered with their ability to finish and market the film, which would have been a breach of her contract. They're basically saying that she was obstructive, unreasonable, and that she caused them financial harm. Ultimately, their response to her motion to dismiss request is much more robust than Blake's to Jed Wallace. They didn't spend 10 pages revising and rehashing the facts of the case to give a background. Instead, they used details of the First Amendment complaint to argue against what she was saying should be dismissed, which is how they're supposed to be made, like how these responses are supposed to be. They're not supposed to be like what Blake did. And here I think they have a lot of really solid arguments. And I don't see this getting thrown out because over and over and over again, a lot of the stuff that they're saying are her arguments are either frivolous or what she's stating and wants the judge to do is not a matter of law. It's a matter of fact. And that can't be determined until they go through discovery and otherwise through a summary judgment or with a jury. I don't see her case getting thrown out at all. Brian Friedman, I'm going to end this by sharing his statement. In a statement to TMZ, he said, Miss Lively and her circle of Hollywood elites cannot prevent my clients from exercising their constitutional right to petition the court to clear their names from her false and harmful claims. What Miss Lively is attempting to do is to set a dangerous precedent by barring the courthouse doors to my clients and punishing them for having their day in court, a right protected by the First Amendment. This right protects not only Mr. Baldoni and the Wayfarer parties in this particular case, but all Americans in the future who have false accusations levied against them and seek relief from our justice system. He also said, this must stop here, and we will continue to fight against this blatant attempt to block access to the court system and to weaken our nation's constitution to serve those who are in a position of power. Naturally, Blake could not let them have the last word, right? And so her lawyers said, that's right. Justin Baldoni, the man who has built his brand on supposedly speaking up for victims, believes that the First Amendment rights of victims of sexual assault and harassment to speak out should give way to the rights of perpetrators to sue their victims into oblivion. Adding that Brian are so hell-bent on destroying Blake, they're trying to shed a law meant to protect victims and send a chilling effect to others from speaking out. Okay, so obviously, Brian Friedman responded and said, this convoluted statement makes it abundantly clear that Miss Lively and team are rattled and once again resorting to making inflammatory remarks to steer focus away from the actual facts. Clearly, they want to divert the public's attention from the receipts, the actual documents, the video footage, and additional evidence shown that make it irrefutable that there was no sexual harassment. It's also surprising that Miss Lively and her team are suddenly speaking so passionately about the hard-won rights of the survivor community, considering she sidestepped this topic for the entirety of the film campaign, focusing instead on her own hair care and alcohol products, which at the time caused the organic backlash that she received. She does not need discovery to find out who smeared her. Just a mirror will do. Oh, I'm so glad he said that she's speaking up for victims now when she didn't during the promotion, which is what caused the backlash to begin with. Oh, I love him. So what are your thoughts about this? Do you think that he has good arguments? Do you like how he laid this all out? Are you surprised to learn about what the contractual obligations were and how she actually breached it? And what are your thoughts about him literally saying that she lied in federal court? Tell me in the comments below. Make sure to give this video a thumbs up. Please subscribe to my channel if you haven't subscribed and click the bell so you never miss a video. Thanks so much for watching. Bye, guys.